Welcome to the next episode of Call to the Bar, International Law Over Drinks, a series of casual conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we are speaking off the cuff and without the benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. I'm your host, Dr. Juliette McIntyre, Senior Lecturer in Law at the University of South Australia, although now technically the New Adelaide University. And joining me today is Tamsin Phillipa Paige, Associate Professor at Deakin Law School, and Douglas Guilfoyle, Professor of International Law and Security at UNSW Canberra. Welcome. In today's episode, we will be pondering the perplexities of piracy. While this isn't one of our what everyone gets wrong about a case episodes, it's kind of like what everyone gets wrong about an entire sub-branch of law. Two of the world's leading pirate experts, that is, people who know lots about pirates but are not, to my knowledge, actually pirates themselves, will be sharing with our listeners their personal peeves about the way international law deals with pirates and the misunderstandings that are rife in the area. Or in other words, what makes them want to go, "Arr!" Okay, I'll stop now. But before we get down to business, our traditional first question. What's your drink? Douglas?
Well, I am just finishing my second cup of coffee for the morning. It's an AeroPress filter coffee with oat milk. And yeah, the caffeine's just beginning to touch the sides.
Tamsin?
I have two drinks this morning. I have a coffee drip filter with a single origin Brazilian bean from Patio Coffee, and that's really stock for me. But the exciting one is I have a pot of butterfly mango dragon fruit white tea, which is
Wow.
a Bai Mudan white tea, which is, I understand it, a Chinese white tea. And it's got butterfly pea flowers, dried marigolds, and dried mango and dragon fruit in it. But what's really exciting is it's fucking blue.
I was going to say, is it blue? Because of the,
Yeah, it's fucking blue. The tea is just blue. And
Amazing.
it's ridiculous. It's delicious, but it's also ridiculous. And I've got blue tea that is actually naturally occurring blue as opposed to weird chemical blue, and I'm a little excited.
So pretty. I also am on the caffeine, though, given that it is still before 11 a.m. here. It's some kind of batch brew, and it's very large. That's about all I can tell you about it. But look, let's begin with a bit of a simple explainer for those who may not be as familiar with this area as the two of you are. So let's start off with what piracy is and what it is not. So where does the law governing piracy come from? Is it customary international law? Give me the 401.
Okay, so I'll start and Tamsin can correct me. Look, the generally accepted definition of piracy is now found in the UN Convention on the Law of the Sea, and broadly it consists of any unauthorized act of illegal detention, depredation, or violence committed on the high seas from a private vessel or aircraft against another vessel or aircraft, or any property outside the jurisdiction of any state. So the core definition, we usually break it down and say you have an illegal act, you have two vessels involved, one of which must be a private vessel, well, the attacking vessel must be a private vessel on the high seas. And these acts are said to be done, for private ends. And we can come back to the whole crap show that introduced to the law. But where does it come from? So everyone will go, oh, well, piracy is ancient. It's an ancient part of international law. And this is where Tamsin and I start groaning deeply, because throughout the 20th century, there were various efforts to work out what the law of piracy was, most of which had to concede that they didn't really know before we got to the modern treaty law. So the very rough history is the League of Nations looked at this issue. So there was a big craze in the early 20th century for codifying international law, writing down rules that were generally thought to exist. The League of Nations looked at the question and then decided after a couple of reports and a few debates, it wasn't of sufficient importance to consider further. The Harvard Codification Project in the 1930s brought together about a dozen supposed international law experts to look at the question of piracy. None of them had any background in the law of the sea. They produced a massive report, which started off by saying, yeah, when you go looking for a definition, unfortunately, all the sources contradict each other. So this is what we reckon, we guess. But at that time, a huge issue was the status of Civil War insurgencies in Latin American wars of independence, and what happened when essentially what we'd now call a non-state actor goes to sea and perhaps starts attacking shipping. So that was a particular context. Then the International Law Commission looked at the question of piracy. And actually, I reckon if you go back through the historical records, which everyone looks at with a particular eye just to prove their point, actually what happened is the International Law Commission reporter, JPA Francois, was bullied into adding piracy into his articles on the High Seas Convention. He went, wait, this is a criminal jurisdiction issue. You recruited me to write the report on freedom of navigation on the high seas. Why the hell am I doing this?
Not just that, it was bullied into it out of a sense of historical propriety of the High Seas Convention should have something about
Right.
piracy for historical propriety, not because we think it's a real issue.
Right. But also he was basically told to do it by the chair of the International Law Commission, Manly Hudson, who had also been deeply involved in the Harvard Codification Project and said, don't worry, it won't be too much work. You can just go to the Harvard Codification Project. So Francois, with very bad grace, only after being told to do it twice, copy-pasted the Harvard codification work into his draft articles, at which point everyone said, aren't these too many articles on piracy? And at this point, Francois was just like, make up your mind. Like, just make up your mind. I don't want to be here doing this any longer. Anyway, then the draft articles are picked up by a UN negotiation process on the high seas in the 1950s. And basically everyone's like, oh yeah, piracy, whatever, not that big a deal. We'll just copy paste forward whatever the International Law Commission reckons. That definition goes into the High Seas Convention. And then with trivial amendments, it goes into the UN Convention on the Law of the Sea. You then have people like Alfred Rubin, one of the classic writers on the law of piracy, going through all the historical evidence and going, yeah, whatever the International Law Commission was doing was not codification because the sources are too contradictory to codify anything. And his very eccentric conclusion is therefore that there is no customary rule on piracy. It just got invented in the 20th century as a matter of treaty law. And there are all kinds of reasons one could refute that conclusion, but it just sort of shows you how confused the whole issue is. The other thing is, the moment anyone says the word piracy, everyone goes around, ignores the actual treaty text in front of them and goes scrabbling around for lots of historical sources because they're really convinced that that's where the truth of the law of piracy must be hiding. When everyone who's ever looked at the issue goes, the historical sources are a mess. The only basis for a rule we've got is the treaty rule that's been repeated a whole bunch of times by a whole bunch of states in different contexts, which kind of suggests they think it is the customary law, even if maybe that isn't a very historically grounded conclusion. Tamsin, stop me before I go.
I'm gonna go
Hang
to
on, hang on,
no, hang on.
Wait, no. I just have to like throw in a comment for like the people who aren't pirate experts here because that was wild, right? Like we all know, like pirates are pirates, right? We all have a visual image of what a pirate is, and we can, we're like, yeah, pirates are a thing. They're on boats. They're from the 17th century. That was a wild story. I want to hear Tamsin's version, but
Okay, so I'm going to now go through what those historical sources kind of did because I looked at all of those historical sources to determine if piracy law actually has any value or purpose. Spoiler alert, it doesn't. Mostly, it does nothing. It maybe encourages some people to do some other things that actually help the problem, but the law itself, fucking useless. Um, but so whenever anyone appeals to the historical, they go back to my old mate Cicero. They go straight back to the old mate Cicero and go, well, when some pirates captured Caesar, Cicero said that pirates were hostis humano generis and they declared war on the world, and therefore, fuck it, we can do what we want. And this is the origin point of people's historical analysis. And at this point in time, a shout out to Mark Chadwick for being the only person who starts with this who's not completely fucking bug nuts crazy. Um,
Small sidebar, yeah. Hard agree. Anyone who begins a piracy analysis with hostes humani generis, A, doesn't know what they're talking about, and B, makes me want to just kill myself. Like, kill me now are the first words through my mind when I read that Latin phrase.
Oh my gosh.
yeah,
But
this,
we've got like you've got like two choices have been presented with so far, which is either it was made up in the 20th century or it's from Cicero. That's
oh,
pretty
no, no, no.
like
Cicero's just the starting point of when it was made up. We then move on to Grotius and Gentili,
Oh
who
wait,
okay.
have latched on.
quick sidebar on Cicero. The historic consensus is he was misstating the Roman law anyway.
Yeah, this is true, but it's Cicero. Of course he was. There is nothing more satisfying in the world than playing Expedition Rome's and shooting Cicero in the fucking head with an arrow for what he's done to my job over that statement. As an aside. However, moving on from that point, we then get to Grotius and Gentili, who invoke the phrase as a bit of political rhetoric, and then come to the conclusion that, you know, sovereignty on sea is derived the same way as sovereignty on land through the effective control through use of force. So you just get jurisdiction by being there with more guns. Um, is how we then got a jurisdiction over pirates because they didn't have a sovereign that they were adhering to and therefore weren't governed by the prisoners of war and laws of war in naval warfare. And that's actually pretty reasonable. However, we then move to the British judges and Cook, it's spelt Coke. It's weird. I don't understand. But um, who said that no, piracy is petty treason against the sovereign, and if you've done it against and you invokes hostis humani generis, say it's petty treason against all sovereigns, and then carried on from there. Um, but then we have the actual practice through that period, which was piracy was only ever invoked when privateers had outlived their usefulness to give them a legal recourse to execute privateers who were no longer doing what they were told by the crown. Never used in any other context as an area of law. Pretty much, except for the bounty statutes in the 1800s from the British, which were mostly used by the Royal Navy to kill indigenous people and get paid for it because the bounty on killing someone on a boat was 5 times that of capturing them. And so they literally, we've got cases on this in the Magellan Pirates and the Sir Hassan Pirates cases, where the Crown actually questioned the bounty statute application about whether or not they had to pay it out to these Royal Navy sailors for killing indigenous people in the South Pacific and Southeast Asia, where the British court said, well, they were on boats and on the water. What more do you want? They were pirates. Pay the bounty. And that's kind of basically that's all the piracy we have really happening after the Napoleonic Wars. And this is still not even helpful for this question of what is custom, because mostly it's like pirates are whatever the fuck we feel like at the time. So, which then gets us to the story Douglas told.
So, but also just to put a kind of a bow on that. So, I mean, the story Tamsin is telling is really one of basically how do you fund a navy, right? So before you had standing navies, you had privateers, essentially, the equivalent of private military security contractors out raiding enemy commerce and self-funding. And then when you did have a navy, it was still pretty badly underfunded, right? And one of the ways you got income as a sailor in the navy was things like the bounty statutes, or taking a share of prize when you captured something at sea. So it's really about how do you finance the British Empire, which is built off the back of a navy. Just on the Coke thing, again, the reason he latches on you're at war with everyone, which does so much damage to the later law, is just a quirk of criminal law in the British conception at that time, which was that crimes were things that you committed against the sovereign. It was the sovereign's peace you were breaching. So all crime to some extent was, particularly violent crime, was a species of treason. But then British criminal law couldn't apply to someone who owed no allegiance, right? So you had to say it was petty treason against the world. It wasn't meant to be a statement about what piracy law was fundamentally. It was just a way of reverse engineering jurisdiction for a British court. The one historical sort of anecdote I'll lay onto, or historical layer I'll lay onto what Tamsin has laid out is, this debate in the late 19th century about the status of civil war insurgents in Latin America. And this again has nothing really to do with the law of piracy. It's much more to do with what we'd now call the law of recognition. And this is where writers like Lauterpacht got really sort of involved. And it goes to things like the recognition of statehood we've talked about in other episodes. But in this case, it was more about, what do you do when a colonial government has been overthrown by an independence movement? Who is responsible for the damage done by the independence movement along the way, right? And so we now have an article in the Articles on State Responsibility for Internationally Wrongful Acts that says that, essentially a revolutionary movement that comes to power, state responsibility is kind of reverse projected onto its actions when it wasn't a limb of state. And you had similar questions about what do you do with an unrecognized insurgency at sea, as I said before. Are they pirates? Are they not? And this was essentially a question of, a branch of law that doesn't presently exist, really, which is the law of naval warfare during a non-international armed conflict. What rules bind non-state actors? And essentially the compromise they kind of came to was, if the flag state hasn't recognized the insurgency, and recognition of insurgency was a big thing at the time, then it can treat violence done to its shipping as piracy. So it was really a sort of hybrid question of the law of neutrality and the law of non-international armed conflict. It wasn't directly a question about piracy.
I'm
This
going
is so
to
fascinating
add.
because
Hang on, I
go
need
on.
to add. I need to add something on to the how do you fund a navy. It's worth noting, and this will come up as an important thing with one of your later questions, that in 1856 the Declaration of Paris was signed and everything like that, that forbade the use of privateers, and that has since been recognized as custom, probably well before World War One.
Yeah. So this is so interesting because I think there is this presumption that a lot of people hold that piracy would be this really old crime that's kind of, well recognized and it's very obvious. And I feel like I've been misled by many cartoons about, the way this all sort of actually played out. So look, if what then? So you've mentioned, insurgency and coups and these things in this context. So what then is the difference between like a pirate and a terrorist? Is there
Oh God, kill me now.
one?
Okay, so it's worth
The
noting
second
that
time you said that, Douglas.
Douglas and I had an 8-year disagreement over this point before realizing when we had to co-author an article where we had to hash this out that we actually were disagreeing over different things and we actually mostly agreed. And most of the caveats on pirate versus terrorist, blah, blah, blah. My concern was about the failure to recognize belligerency and to avoid IHL obligations by declaring someone to be a terrorist and then therefore using the laws of piracy rather than IHL to deal with them. That's kind of I actually agree now with Douglas that that's not the best way to deal with that question, even though the concerns are legitimate. So I'm going to let Douglas go into the public versus private debate.
Oh, okay, right. So everyone who says that a terrorist cannot be a pirate hinges their argument on one thing and one thing alone. It's that the High Seas Convention, I'm already massaging my temples, that the High Seas Convention and the UN Convention on the Law of the Sea say that piracy, this unauthorized act of violence on the high seas from a private vessel against another vessel, must be done, quote unquote, for private ends, right? Now, those words, again, have done, those three words, like hostes humani generis, have done untold damage to the clarity of the law. So the argument is that was sort of received and accepted bizarrely in a lot of textbook writing for a long time is that if you have a political motivation for violence, then you cannot have been carrying out the violence for private ends. Okay, that makes some sense if you don't apply any legal reasoning at all to that statement. And why I say any legal reasoning at all is that as Anglophone lawyers, Juliette, pop quiz, what is the opposite of public in law usually?
Help. What if I don't know the answer to that? Private?
Exactly.
Well, I was like worried I was going to get that wrong for some reason.
It's not the political, right?
Yeah.
We normally talk in law about a distinction between public and private, and in criminal law between public and private violence. Violence is okay. I mean, not necessarily politically, but legally, the state, Tamsin put heavy air quotes, but the state has a monopoly on violence, right? So public violence, when it is done in an authorized manner by a military or policing agency, the law recognizes. Private violence, if I engage in an act of vengeance or revenge or robbery or murder or assault against you or Tamsin, the law does not recognize and stigmatizes. At no point do we ordinarily say in a system of law, my deeper motivation for committing that act of violence is relevant. We normally go, no, you committed the violence, it was private violence, you intended the violent act, whether you did it for a political reason might be an aggravating factor, but it is not actually relevant to whether an offence of, say, assault, robbery, battery, kidnap, whatever, was committed. Okay, so, but we get hung up on this distinction because of episodes of terrorism, particularly in the 1970s. And again, the language gets really confused because before there were aircraft hijacking conventions, people talked about air piracy, right?
Which, to be fair, I'm always disappointed doesn't involve dirigibles floating down and people rappelling onto decks from dirigibles, steampunk style with cutlasses. Really fucks me off. That was like my life goal as a child.
Yeah. Oh well, wasn't it for all of us? So you have this loose use of air piracy until you get the aircraft hijacking conventions, and then you have a particular incident that Tamsin and I can go on about forever, the Achille Lauro, in which an Italian cruise liner is hijacked by the people, the Palestinian Liberation Front, the PLF, not the PLO, but they board as passengers. So it's an internal seizure of the vessel. Off the port of Tartarus, they kill one hostage, Mr. Leon Klinghoffer, a Jewish American in a wheelchair. They demand the release of many Palestinian prisoners in Israel. They get nowhere. Egypt offers them sanctuary. So if they'll release the hostages, so they take the Achille Lauro into port in, I think it's Cairo. The Egyptians offer them safe passage. They put diplomats of their own with the hostage takers onto an aircraft, a charter aircraft that takes off. This is then intercepted by US fighter jets over the Mediterranean that force it to land at a US airbase in Italy, where there is then a standoff about criminal jurisdiction between the US military and armed Italian police over whether the US airbase is extraterritorial to Italy, which, spoilers, it's not under any status of forces agreement any state would ever sign, right? You hand over jurisdiction over matters of military law applicable to base personnel. And when you hijack hijackers, those people are not part of your military personnel. So eventually the hijackers are put on trial in Rome. Like, this is just a jurisdictional shit fight of the first order. And part of Egypt's defense for its behavior is, well, we had no jurisdiction over these guys. They weren't pirates because it was an internal hijacking. And we weren't the flag state. It was flagged in Italy. And these guys weren't our national. There was no basis on which we could have detained them or put them on trial. And then everyone goes, wouldn't it be great if we had a ship hijacking convention along the same lines as all the aircraft hijacking
I'd
conventions
like to put
we've
an
got.
interjection here.
Yep.
They didn't say, wouldn't it be great if? They said, well, that's clearly a problem with UNCLOS piracy provisions and we need.
Right, right. So then everyone reverse engineers from that piracy, the UNCLOS piracy provisions don't apply to terrorists, not they didn't apply to an internal hijacking.
Yeah, which was a situation where the US tried to claim jurisdiction, where people tried to claim jurisdiction, among other things, on piracy, and UNCLOS and the Geneva High Seas Convention said, get fucked.
Right. Like the issue here was not that they were politically motivated. The issue was that they weren't attacking from another vessel. If they'd pulled alongside in a speedboat, climbed on board the Achille Lauro and hijacked it, it would have been piracy. But it was
In
essentially,
the same,
yeah,
yeah.
it was mutiny of the passengers, essentially.
And in the same way, the USS Cole bombing was not piracy because it happened in port. It was not on the high seas. That's a jurisdictional question and like an element of
Right.
crime question. Stop trying to say that this is a flaw in piracy law. It just wasn't piracy, people.
Yeah.
But so did they sort of like, if I follow you correctly, they sort of just decided to solve this by labeling them terrorists without worrying too much about what that definition might encompass,
Well,
just to avoid
no.
or not. Am I? Yeah.
No, this was a case of they made a new convention
Okay.
to cover ship hijacking, which was the Sewer Convention. But what we have here then is this prolonged argument over, well, if they're terrorists, they can't be meeting the private ends requirements, as opposed to going, no, they didn't meet the two ship requirement, or they didn't meet the high seas requirement, or. And but if they're terrorists, then then they're kind of like pirates, but they're not, also not like
Right.
like combatants, so we don't have to apply the law anywhere. And we'll
Mm.
get to that one shortly.
Yeah.
Mm.
But essentially you wind up with this failure to apply basic legal analysis. There's something about the word piracy and the word terrorist that just creates weird extra legal shortcuts in people's brains.
Not how I'd frame it, but I'd say that they enter this state of quasi-orgasmic legal lack of thought. They hear that and just lose their shit.
Yeah, and go, oh wow, law doesn't apply, blah.
Mm.
Yeah.
But but what the point I was kind of making is we wind up back in this pointless debate about can terrorists be pirates, where you're arguing about abstract categories. And let's remember that, we didn't get anywhere close to a universal definition of terrorism until the Terrorism Financing Convention, right? Because, oh, one man's freedom fighter is another man's terrorist, meant that all the international community could agree was on a case-by-case basis, the following tactics are wrong and criminal, no matter who does them or for what reason. For example, the hostage-taking convention, the aircraft hijacking convention. So we take this sort of salami slicing subject matter specific approach to the issue.
Additional protocols in the Geneva
Right,
Conventions on maybe it's bad to bomb civilians.
right, right. So, and this just gets back to Tamsin's point. Rather than saying a priori, what we can see from all these incidents where terrorists were not pirates, that doesn't add up to an a priori rule that a terrorist can never be a pirate. In each of those cases, an act of terrorism was not piracy because it did not satisfy the jurisdictional preconditions of a criminal offence. It doesn't mean that it never can, that there is zero overlap between the two concepts, and the result was not dictated by the words for private ends. And before we move on, just a sidebar on that. Okay, if uh, if it were the case that for private ends meant that anyone with a political motive couldn't be a pirate, you've got two big problems. First, everyone arrested for Somali piracy should have been able to say, oh, well, I was acting as part of a civil war insurgency, therefore I was politically motivated, therefore I'm not a pirate, therefore you've got to let me off. Or alternatively, the weird and meritless argument, foreigners are stealing all our fish and all we're doing is repelling evil foreign fishermen. Again, political motive. You can't hold me a pirate. No one ever bothered running that defense because it was plainly junk, right? Step. Um,
I saw some plainly junk defenses being run in those courts. Um, so yeah, like the fact that they didn't run that one when they were running some of the other ones, which included, did you ask the men firing at you with assault rifles from 500 meters away to stop? Literally got asked of a master of a vessel in a court case. And so if they're willing to ask that question but not run that argument, it's such fucking bullshit.
yeah. The other point is the only time that argument has ever actually been run has been in kind of direct action environmental protest at sea cases, where if you cross the line from, say, I don't know, aggressive maneuvering of your vessel to try and block an activity you don't like, or holding up protest banners at sea, to actually throwing stuff on board another vessel, potential act of violence. If you cross that line, then you open yourself, even though you think you're being motivated only by good intentions, to crossing the line to piracy. In the same way that violent protest on land is generally illegal. You don't get a free pass because you're protesting a worthy cause. And so, there are one or two reported environmental protest at sea cases which have been charged as piracy, where defendants have said, but I can't be a pirate because I was politically motivated, and courts have come back and said, no, you're still a pirate. The reasoning has occasionally been convoluted and not extraordinarily clear, but again, in any actual case where the defence has been run, it has failed.
Mm.
Looking at you, Sea Shepherd. Looking at you.
Yeah, I was like, are we going to name them? I know who you're talking about. So, okay, so look, it sounds like certainly I have learned a whole bunch in the last 30 minutes or so. And it seems like there's just a lot of misconceptions around this area, both what the origins of the law is and how it looks now, how it should work now. Are there implications for this, like in a broader context, or is this a pretty narrow sort of an issue?
Okay, let me tell you about possibly the worst hot take that does then lead into the real big issue that actually came about from this. The worst hot take was from a man named Douglas Burgess Jr. About 2005, he wrote a paper that started with Cicero. Never a good sign.
Kill me
Uh,
now.
yeah.
That's number three.
Um, possibly go play Expedition Rome's and shoot Cicero in the face to change the course of history for in your own little world. Um, so it started there, and enemies of all humanity and declaring war on the world. It then moves to Blackbeard and goes through a 3.5 page description of Blackbeard boarding vessels to conclude that Blackbeard was a scary dude. Ergo, pirates were Renaissance terrorists. And so, therefore, we have universal jurisdiction over pirates, and because they are Renaissance terrorists, we have universal jurisdiction over terrorists. And because pirates had declared war on the world and they were terrorists, we can apply IHL instead and just drone strike Palestinians.
I mean, look, I'm not an expert, but there's a couple of gaps maybe in there.
I did say it was the worst and most insane take.
So it's what I call the Wile E. Coyote school of argument, where in the old Roadrunner cartoons, the coyote would go to the edge of a cliff, nail a plank to the edge of the cliff, climb out to the end of the plank, nail another plank to that plank, do the same thing again 3 or 4 times, and just before you reach the other side of the canyon, the whole edifice collapses under you. Right? Like each individual plank looks pretty bad and pretty shaky, but by the time you're like 6 steps along, it's just grr.
Yeah, so this is the worst take we've seen stemming from all of this crazy nonsense. Um, but the implications are real. And the implications were actually deployed by a lot of major world powers during the War on Terror to create this grey zone of law. And that was to create this grey zone of law where IHL didn't apply to people we designated terrorists, but neither did criminal law because of the piracy analogy. And so it created this space where, well, they're not state actors, they're not belligerents, they're not this, and this, because so IHL doesn't apply. But pirates are also this special breed of international subject because they've declared war on the world, so we don't have to apply criminal law protections to them either. And human rights just don't apply, and so we can just shove them in Gitmo.
Mhm.
Um, and that's a whole thing. Ben Saul and Gary Simpson have written a fair bit on that. I'd say the most accessible one on that whole thing is the chapter in Gary Simpson's Law, War, and Crime, where he looks and unpacks that analogy deeply. But Ben Saul's also looked at it a fair bit as well, and it's horrific. And it's really not okay, but it also leads to a whole bunch of this losing people losing their mind over piracy also leads to a whole bunch of other problems, which includes well, why don't we just hang Somali pirates from the yardarm like we did in the good old days? And I'm like, because the ICCPR applies and there's a right to life and a right to due process. Or why don't we just get bounty hunters and issue letters of marque? And I'm like, because the Declaration of Paris says no. And then they'll say, well, we're American and the Constitution says we can issue letters of marque. And I'm like, I don't give a fuck. International law still says no. And
And my other one was, if they've declared war on all mankind, why can't we open fire at sea on Somali pirates on a shoot to kill basis? And I was like, well, there are so many problems with that, but let's just start with, whether an international or non-international armed conflict exists between parties is a question of fact. And the fact that there's a non-international armed conflict in Somalia doesn't necessarily mean that there's a non-international armed conflict at sea between these guys and naval forces. You just don't pass the basic threshold tests of
well, and it's the same
controlled violence.
basis of why can't I just declare that I'm a sovereign nation?
Right,
It's the
right.
same logic.
But the other key one was, if you acknowledge Somali pirates as combatants, they have a legitimate right to use force.
Mm.
Okay, and potentially you have less ability to use force against them under a law of armed conflict than a policing paradigm, because what military objective are you
Mm.
securing by firing on these guys? Whereas you've
Yeah.
got a law enforcement mandate to address them whether they are firing on you or not.
Yeah, you just
In
can't
a law
fire
of
on
peace
them
paradigm.
unless it's in self-defense or defense of another person.
Yep. But you also have all these criminal investigatory powers. Whereas if you're
Mm.
doing it under a non-international law of armed conflict paradigm, you've got to go, well, what is your evidence that these guys are currently direct participants in hostilities? Are they firing on you? If not, you've probably got to presume they've got civilian status and therefore let them go.
Yeah, you don't have a right of visit in that regard and all of those things.
Right. So, I mean, I wrote a whole paper on,
I quoted that paper. The simple answer is no,
yep.
was the
So
quote I used.
it's the best single paragraph I've ever written in a law paper, where I outline all the crazy arguments made about applying the law of armed conflict to Somali pirates. And they go, so, the question arises against all of this background. Does the law of armed conflict and international humanitarian law apply to the fight against Somali pirates? New paragraph, one sentence. The simple answer is no. And it is the most emphatic I've ever been as a legal academic. And then the rest of the paper just explains that sentence.
And on top of that, moving on from it, all of these flawed interpretations about what piracy is has real implications, particularly in Southeast Asia. And this goes to what I know we'll discuss later, but it then has issues around the questions about the high seas requirement and does that really apply? And that has real implications for all of the archipelagic states in Southeast Asia, particularly that have issues with what The IMO calls piracy and every lawyer calls armed robbery at sea for very real reasons. And the reason we make that distinction is that if you call it piracy, states have a right of jurisdictional enforcement. And that means that you'll suddenly have the US and China engaging in counter piracy, in quote mark, patrols through your archipelagic waters with all their warships. And no one wants that.
Yeah, like that does you've raised a question that sort of led into my next question quite nicely because I wanted to talk about turning to sort of prosecution or how do we deal with pirates? Because I guess there are some instances that do fall within the definition of piracy. And so, like we know that we have universal jurisdiction over
No,
international
we do not.
crimes. Okay, we don't know that. Over
We don't
international
know that
crimes.
we have international crimes to do, but we do not
Yeah,
have it
no, no,
over
no.
piracy.
Yeah, no, no. So that's my question, right? So we've got universal jurisdiction over international crimes. That's non-controversial. But what about piracy, right? Like that's my question.
We do not, and we never have,
Okay.
and
Mild,
we never
mild
have.
disagreement, but I'll let Tamsin outline her argument.
Okay, so first of all, we don't have a universal jurisdiction. We have a concurrent jurisdiction in the high seas. I call it concurrent municipal jurisdiction, call it what you want, where all states have the right to enforce their criminal law in an area where no one has jurisdiction. That's not universal, because the minute you step into territorial sea or archipelagic waters, you lose that jurisdiction. Ergo, not universal. But we also, once we go, but even people who claim historical basis, once you go back to it, almost every case of piracy that has ever been through a court that we have records of, and I've been through all of the House State trial piracy cases that we have transcripts for, all of them either occurred where the courts had jurisdiction because of the nationality of the perpetrator. So they had that jurisdiction, or they had jurisdiction because they were the flag state vessel. So even historically, the claim of universal jurisdiction is erroneous because jurisdiction is almost always being exercised pre-UNCLOS by states who have a direct jurisdictional nexus to the incident. And so, come UNCLOS, we have this thing of all states have jurisdiction over piracy when it occurs on the high seas because it's a high seas requirement, which is fine. It's not universal, though, and let's stop calling it universal because that creates the misnomers that says we can just drone strike Palestinians because Edward Teach was a scary dude.
So I don't disagree with that line of analysis, and I agree with Tamsin that it can, like, there is danger to the term universal jurisdiction because it gets conflated with other things and used. I think, though, calling piracy a species of universal jurisdiction, like that horse is bolted, and I don't think it is conceptually inaccurate. I think the difficulty is that universal jurisdiction over piracy, such as it exists, is very different from universal jurisdiction over modern international crimes.
Yes,
And I'll just,
and
I'll
sorry,
just,
I was going to add mostly because universal jurisdiction, quote unquote, over piracy is based on statelessness, and we have plenty of jurisprudence that says that universal jurisdiction over international crimes is based on heinousness.
well, yes, but I'd say that universal jurisdiction over piracy is not based on statelessness. I think the statelessness analogy is problematic for a number of other reasons. Essentially, though, what you do have is, which is completely different from, say, universal jurisdiction over war crimes, is you have universal enforcement jurisdiction. In an area of the world with no territorial jurisdiction, the high seas, all states have a right to conduct boarding, search, and law enforcement operations. You do not have the right to go into another state's territory and arrest or abduct a war criminal. Side brackets, Eichmann trial.
Mm.
Okay, so it addresses a different issue. Modern universal jurisdiction is principally about prescriptive jurisdiction. Every parliament, every legislative body in the world can pass a law prescribing war crimes, crimes against humanity, torture, genocide, and say if a suspect enters our territory and sotto voce And sometimes we won't ask if they entered our territory illegally because, our intelligence services kidnapped them. But if they're in our territory, we can then prosecute them regardless of on whose territory they committed that crime, and regardless of whether they're our national or not. So universal jurisdiction over modern international crimes is jurisdiction in the absence of an ordinary jurisdictional link. That's all it means, and it only applies to prescription. So there is no logical connection between and I'm happy to adopt Tamsin's terminology, the concurrent municipal criminal law jurisdiction all states enjoy over the high seas for a fairly minor offence compared to, say, genocide, war crimes, or crimes against humanity, essentially crimes against the person and property. There is no conceptual or historical link between that and the rise of modern customary international law and treaty-based jurisdiction over international crimes. The problem is judges who are, feeling their oats or get a bit antsy will start saying stuff in written decisions like, the torturer is like the pirate, the enemy of all mankind, and hostes humani generis, and both Tamsin and I's head starts to explode. And so there's a half right but mostly wrong, quite famous paper by Eugene Kantorovich called The Piracy Analogy, Modern Universal Jurisdiction's Hollow Foundations, where he says, well, because for all of the reasons Tamsin raises, piracy is not really a form of universal jurisdiction, therefore national courts risk overreaching their actual authority under customary international law, because when they say the basis for modern international crimes is hostes humani generis, that does not sustain a claim to universal jurisdiction. And I'm like, yes, if that was the basis of the claim to universal jurisdiction, as opposed to a wacky obiter dicta, that argument would hold. But it's just a wacky obiter dicta, right? We have a completely separate foundation of customary and treaty law for modern universal jurisdiction. There is no relationship to piracy other than in the heads of some crazy judges and some just as crazy academic commentators.
I'm feeling like this phrase. I'm never going to mention this hosti humanus generis phrase ever again. It's like very triggering. Okay, so it's sounding a little bit like this, that piracy is this sort of fairly unique, sui generis little space that has particular rules. Would doing something like setting up an international piracy court, be a good idea to deal with this unique little area?
No. So I've got another paper on this. Like, again, during Somali piracy, everyone was like, it's an international crime. We need an international court. And I'm like, no, we don't.
There was also an argument that we need a UN Security Council referral to the ICC for it as a crime against humanity, which I found also, I didn't agree with it. Let's just put it that way.
Yeah. So look, the simple argument is that, just the pragmatic bit. You don't whether international courts are even the best way of prosecuting international crimes, I think is now fairly open to question. The International Criminal Court is slow, not particularly effective, and I'll stop at that, right? Like it takes forever to achieve not very much. And if you look at the number of cases it's finalized compared to the International Criminal Tribunal for Yugoslavia, it's not very impressive. And the ICC has now existed for longer than the ICTY ever did. Now, there are all kinds of reasons that the ICC can point to in its defense, going lack of state cooperation, we're too jurisdictionally spread, so on and so forth. All of that can be true, but it just points to the fact that international criminal tribunals might not be the most effective way to prosecute international crimes. And whatever its flaws, the system of, in the case of Somali piracy, some states with naval assets do the policing, and then some local states without the naval assets do the prosecuting, was a fairly workmanlike solution. You had to ensure that that whole chain of custody was human rights compliant. I say it was. Others raised some questions about that. But at the end of the day, that was a far more effective and efficient way of actually prosecuting some pirates than setting up a permanent tribunal somewhere random with an enormous budget to do the job.
Possibly floating on the high seas so no one could claim asylum after being released
Oh,
for their
shoot me
for after
now.
serving their time. And
Yeah,
I'd like to
there
point
was more
out,
than one proposal that you would have literally a floating international piracy tribunal during the Somali piracy crisis, largely as a way to avoid refugee claims or human rights conventions. At which point I'm like, if you have extraterritorial human rights obligations, which generally I believe that you do, not every lawyer does, but most.
I'm pretty certain the European Court on Human Rights has said that you do, and the Europeans were the ones doing most of the
Well,
enforcement.
exactly.
So
And
let's just
where
go with
is your
yes, you
sovereign
do.
control? Where is your sovereign control and jurisdiction stronger than on a warship, right?
Mm.
So if the question is, are they in your jurisdiction and control? I'm like, warship, warship.
Yes, Warship says yes.
I will note, just as a sidebar, that the African Court of Human Rights has, under its statute, should it become fully operational, as an amendment, a jurisdiction over the crime of piracy.
Yeah.
Lord knows
Uh,
why, but they just bundled it in.
well, I think that actually stems to the concerns that individual states had over repatriation to Somalia of convicted pirates. That was a big issue that came up
Yep.
in the field work I did on this. Everyone was pretty satisfied that the prisons that were being built in Somalia for repatriation were human rights compliant. There were some concerns raised, but mostly the UN development program were building them and organizing and overseeing the running of them, and everyone was pretty satisfied they were human rights compliant. There were questions over the Kenyans prisons due to overcrowding, which was why Kenya stopped taking pirates for prosecution, and most of them were going through the Seychelles. Um, and so, yeah, like for all of the problems that the domestic prosecutions had, they were pretty efficient. Although it did lead to possibly one of the best moments of field work. I have two moments in my fieldwork notes from sitting in Seychelles courts watching piracy trials, and one of them is an accent issue on cross-examination, where we've got a Seychellois barrister for the defense, for the pirates, cross-examining a Greek master of a vessel. And he's asking what precautions that the Greek master had taken on his vessel to prevent pirate boarding. And one of the comments was razor wire. And the judge misheard this. And the judge, being Ugandan, misheard it, and there was an accent difference. And he's like, "Tell me about this laser wire." And there's this back and forth between the witness and the judge over the master of the vessel going, "It's just razor wire. Like, what do you need? It's like laser wire. That's it. Tell me about the lasers." until until the prosecutor stepped in and said, said, Your Honor, I think there's been a miscommunication here. He said razor wire, not laser wire, and we all moved on. The other one that was fantastic was that one of the trials that I was watching had a Dutch naval crew had done the boarding and capture, and they were going through the boarding process, and one of the marine, I think sergeant, was being questioned, and the defense counsel kept saying, "So why did you do that during the boarding?" And the sergeant said, "Because I was ordered to." And it just kept going back and forth, where the sergeant couldn't understand that he needed an explanation for the defense counsel beyond "I was ordered to, so I did it," which then ended up after about a back and forth of about 2 minutes with defense counsel rephrasing the question and just getting "because I was ordered to," ended up with a notation in my fieldwork journal of "fuck, Marines are hilarious." Um, and so, yeah, you have instances like that happening in domestic prosecutions, but mostly they work, and we
That's kind of
don't
like
need it.
like any criminal prosecution has its quirky moments
Moments.
probably.
Oh,
And yeah, like if we don't have I don't know, an international genocide court or something, piracy seems like
Yeah,
small fry in comparison.
the issue with domestic prosecutions and is the fact that there's a capacity issue, much like anything else, and because no one wants to fund it.
Hmm.
And during the height of Somali piracy, around 95 to 98% of pirates were released without charge because there was no capacity to prosecute them.
Mm.
And so this is why I go back to the criminal law is fucking useless because no one wants to prosecute them, the low level at sea pirates. Everyone wants to prosecute the organized crime group leaders, and the Afghani senior prosecution is one of the highlights of my scholarship. Reading that, how they got around, how they made that happen. Um, I'll let Douglas tell that story though.
Oh, no, look, Tamsin, you should tell it, but probably briefly in the interest of time. I will just note that technically, fact checking myself, I believe the Malabo Protocol of the African Court of Human and People's Rights came into effect in 2023, and that means under Article 28A1, if I'm not misremembering, there is now technically an international tribunal with jurisdiction over piracy. So there is one. I doubt they're going to get any cases, but technically there exists now an international piracy tribunal of a sort.
There you go.
Yeah. Okay. So the Afghani senior case was a Belgian case, and Afghani senior was a piracy organized crime group leader who, after making a shitload of money, went, I'm retiring. I'm now going to dedicate the proceeds of piracy to community building and being a good citizen, blah, 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 blah. And
Seems good.
as and so the Belgian prosecutors concocted this scheme to invite him to come to Belgium to consult on a movie about Somali piracy. And so he did and was promptly arrested. Um, because he thought, oh yes, of course, I'll go to a place that has jurisdiction over the crimes I committed. Because one of the piracy hijackings was a Belgian flagged vessel, so they didn't even try and run the links on piracy, organized crime group leaders. They just did it under the hostage taking convention and things like that. But just was like, oh yes, of course, this must be legitimate. These people in Belgium want me to consult on a film. The other one that was great was the Ali case in the US, where I've read through all the procedural stuff, and the US prosecutors were literally trying to lose that case, and it eventually got thrown out. Um, where they invited the negotiator for a number of hijackings, who also happened to be, I think, the Puntland Minister for Education, to the US for an educational conference, and he went along and promptly got arrested for piracy, which then led to a judgment from one of the US federal circuit courts that just said that he had committed the crime of privacy, which just seems like the most US thing ever. That typo got promptly corrected, but I have a copy of the typo judgment.
Oh, it seems apt. I mean, they began as privateers and then they became pirates, and now we have a crime of privacy.
I
Um,
will just say before we move on, Juliet, and I'm sure we'll need to wrap up shortly, that there's an interesting wrinkle in the drafting of the UN Convention on the Law of the Sea, which means that, and this again became a point of silly debate. Can you commit piracy from dry land? And essentially, bottom line, the aiding and abetting offences that are listed under piracy are not on their face governed by the geographic limitation that applies to the primary offence. So the primary offence is, committing an act of violence on the high seas from one ship against another for private ends. Then in a completely separate section, without that geographical constraint, it says the crime also includes any act.
Facilitating.
Yeah. So that became a question as, can you go after the kingpins if they never set foot on a boat? If they were just facilitating people who were on a boat.
And the consensus amongst people working on the ground is yes, through conspiracy and aiding and abetting. And the only jurisprudence we have on the matter says yes, provided some of the piracy occurred on the high seas, it becomes a single continuing act, covering where jurisdiction is transferred across all acts related to it.
there you go. Well, this has been absolutely fascinating. Thank you. I have learned, I'm sure our listeners, like I have, learned a huge amount. And we will no longer be using certain Latin phrases. But look, we like to end usually on a lighter note. For example, my fun fact, which I've told to Douglas more times than I can count, which is that there's an Italian pop star called Achille Lauro, and he chose his stage name as a result of that particular incident. Um, but I'd like you both to give our listeners some pirate themed recommendations. Do you have a particular, you study the area, but do you engage in pirate themed media? Do you have a TV show or a film that you might recommend to our listeners?
Tamsin can answer at some length on this, so I'll try and be brief. But I think, my first all-time favorite pirate from media was obviously the Dread Pirate Roberts in The Princess Bride. And we don't need to say anything more about the glory that is The Princess Bride. But more recently, I've been loving the 2 seasons of Our Flag Means Death, which is a gay pirate romance between I think his name was Steed. I've momentarily forgotten his first name, who was known as the gentleman pirate, who actually like liquidated his assets, bought a pirate vessel, paid his pirates a wage, and was apparently this not enormously successful pirate, having just decided that he would take to sea it as a matter of romance. And Edward Teach, Blackbeard himself, and the leads are played by the amazing New Zealand actors and comedians Rhys Darby and Taika Waititi, and it's a hilarious romp, which also has lots of commentary about, all the things that actually piracy also seems to invoke about gender and sexuality and transgressing boundaries. On which, over to the truly qualified expert, Tamsin.
Okay, so I'm going to go with as much as I enjoyed Pirates of the Caribbean, which was a story about Elizabeth Swann. Everyone else was a bit part in her story. It was not about Jack Sparrow, it was about Elizabeth Swann. Moving on from that, um, Black Sails. You have to go watch Black Sails. It is a fucking masterclass of storytelling. It's set in the historically existing period that is the Free Pirate Republic of New Providence Island. At the end of the English and Spanish War that got settled with the Treaty of Utrecht in like 1815, 1814. Um, so it's like the death knell of Caribbean piracy. But it's also a prequel to Treasure Island. So it tells the story about how the treasure got to the island. So you've got this blending of historically existing people and pirates who we have, sketchy information about, and telling a story about how they all interacted with the British. They make the phrase when civilization returns to Nassau because they know that now that the British are no longer occupied with the Spanish war with the Spaniards, they're going to come back and try and take back New Providence Island from the pirates. And so it's telling the story about what the pirates are doing in response to that, while also telling the story about how Captain Flint got that treasure on that island over 4 seasons. And it is the original gay pirate show, despite Our Flag Means Death. It is the original gay pirate show, and it is amazing. And if you want to know more about how it relates to law, you can read my paper that is entitled "The Whore That Lost Everything," and that is a quote from the show. So otherwise, I wouldn't normally use slurs for sex workers, but I'm using a quote in the title of that because it frames the entire paper.
Yeah. Oh, look, I have watched all 4 seasons on Tamsin's recommendation, and it is so good. I got to tell you guys. So, like, if you haven't seen Black Sails, you absolutely must go and watch it as soon as humanly possible. All right. Well, thank you both so much for that elucidating and possibly for you migraine-inducing episode. We will see you all next time on Call to the Bar. Thank you very much.
Okay, bye-bye, everyone.
Bye.